Welcome to this presentation on procedural law.
To begin this lecture, I want to highlight the extremely important insight with which the book begins. Legal processes for solving disputes are not the primary processes for solving disputes. They are actually secondary, subsidiary, and the so-called alternative dispute resolution is not alternative, it is the normal mode of operation of people in society. If people have a dispute, they will solve it through negotiation, bargaining, by taking the advice of friends, and so forth. The great majority of disputes in society are never litigated. This can be illustrated with a famous pyramid image. Let's call it the image of litigation. And here we can see that the majority of cases in the bottom rung of the pyramid, over here, they're just never litigated. They are solved by the so-called ADR, which, as I said, is not alternative, but it's the main form of dispute resolution, different forms of informal talking, negotiation, bargaining, and so forth. Then we might imagine that there is a still large, but not as large percentage of cases where people take lawyers' advice, but they do not go to court. Let's say I'm angry, I cannot find a solution with a friend, I go to a lawyer, my lawyer says, settle the issue, don't litigate this, it's going to be too costly, too time expensive, and you're probably not going to win. So let's say the law shows up here, but it does not show up here in a way to settle the dispute, but only in a role of informing people of what they might expect. Then even a smaller fraction of cases might go to court, but they will go only to low-level courts. Low-level courts will have enough power and authority to settle the issue with finality. We go to court, I lose, and I see that my chances of winning are very limited, I do not take the matter further. It is only a small fraction of cases that will receive protracted litigation in court, an even smaller fraction of cases that will go to the highest courts of the land, the Supreme Court or the Constitutional Court. So there you get an idea of that legal procedures, they are the very important part of this, but really they do not cover everything of legal dispute resolution. They only cover, let's say, the really problematic cases. For the other cases, you can rely on other forms of dispute resolution that are more informal and also more, in that manner, more cost effective. Having gotten that out of the way this presentation will be structured is by clustering the discussion of the chapter of procedural law into 5 big rights. So I'm going to say that judicial procedures are special procedures in the law that have a form of equality between the parties and which are directed to establishing the right application of the law to the true facts. And these procedures, they are framed by a set of guarantees that I'm going to cluster in 5 headings. Guarantees of the judicial role, guarantees of access to court, guarantees of fair trial, guarantees relating to the assessment of evidence, and guarantees of appeal or of second opinion. And that is going to be the itinerary of the presentation. We can understand the legal process as a special regulated process that aims at finding the truth, the correct application of the law to the true facts, and that operates in a form of equality between the litigating parties. Essential to this legal process is the judicial role, the judge being the person who's in charge of ensuring the equality of the parties and the correct application of the law to the true facts. Because of the importance of the judicial role, the importance of the judge, this role is protected by the law. The law guarantees the independence and impartiality of judges. We can understand as independence as the judge being free from undue influence from outside. Let's say other powerful people trying to persuade him to make judgments in their favor. We can understand impartiality, by contrast, as the judge being free from bias from inside, that is, he himself not having friendship or enmity with one of the parties. The independence of the judge is protected by many legal guarantees, and these change from country to country. But for example, here we may have rules of appointment and dismissal that says that a judge is appointed by other judges on purely professional criteria, not by politicians on grounds of political favoring, and that the judge can only be fired for if he is found to commit a crime. So judges would have a form of tenure. Once they are appointed as judges, they have job security. They cannot be fired unless you find an extremely serious misdeed on their part. Impartiality is protected by the duty of judges to recuse themselves from a case if they find that they have friendship or enmity with one of the parties. Of course, we do not leave this to the hands of the judge only. If a judge does not recuse himself, the parties can also challenge him and essentially raise an incident within the trial saying, okay, this judge is not fit to judge this particular subject matter because I can prove that he is my friend or that he is my enemy. These principles of impartiality and independence, it might be good to balance them with a third principle that the book does not mention. That is the principle of accountability. And this is the idea that judges must also be responsive to society, that they cannot be 100% independent. And here is when we find that some countries have some forms of democratic elections of judges, because the thought in these countries is that judges, they have essentially still have a public office, and that we want judges not only that have good grades in judicial school or that pass the judicial exams with the highest grade, not only professionally competent judges, but also judges that share the outlook, that share the common sense of the population. And there, if you take that additional requirement there, you would want to say that independence cannot be the whole story, that you also want judges that are in some degree responsive or accountable to the views of the democratic population. Now we have the protection of access to court. This is a fundamental right that we find in Article 13 of the European Convention of Human Rights, but it's present everywhere in the liberal West. We must think about this in this manner. What is the point of having this idea of the judicial process as this fair process that is equal across the parties and is directed to the right application of the law to the true facts? What is the point of the existence of this process if I cannot get to it? If, for example, some medical doctor says that I should be classed as insane and then put in a special asylum, and then it would simply be that the judgment of this doctor is the final word because he's the expert. Or if, again, some sort of professional association, the Association of Accountants, says that as an accountant I've engaged in malpractice and that therefore my license to be an accountant should be suspended. If the final word is the word of the doctor or the word of the Board of Accountants, then I would not have true access to court. Access to court means that in law, it must be possible for me, if I have this sort of dispute, to go beyond the opinion of the doctor, to go beyond the opinion of the Board of Accountants, and go to find a judicial settlement, a judicial opinion on this matter. So the law must make it available for me that if something is harming my interests, sometimes is harming my rights, I can have recourse to a court where this fair and equal process could be triggered, and I would have a chance to fight this under the law. Access to court also means that my ability should not only exist in law, it should also be protected in fact. And then, for example, if in the case of that I am being put into a mental facility, mental hospital, because a doctor thinks that I am not of sound mind, if I do not have enough money to pay my lawyers to be able to discuss this in court, the state should be able to fund me some sort of legal counsel. So I should be able to fight this in court, both because this is allowed and because the means are provided for me to actually, in fact, be able to do this. The right of access to court cannot be unlimited. An unlimited right of access to court would, for example, allow me to litigate whether, in my opinion, the Netherlands should stay or leave the European Union. You can immediately think that this would be an impertinent form of litigation. It's not for me and it's not for judges to decide on this political issue. In fact, probably nobody wants to make a decision on this political issue because people are satisfied with things as they are now. But this cannot be allowed. And if I go to court presenting something like this, my case will fail. And it will fail because it will be rejected under rules of standing. The rules of standing are essentially rules that say, is this case, is this litigation pertinent to your rights and interests? If it's not, then it cannot be countenanced. It must be rejected in limine. And then the example there, if I say, I think we can litigate that the Netherlands should leave the European Union, this would simply be something for which I have no standing. In this case, because it's a political question and because I do not have a right or legally protected interest that the Netherlands leaves or stays within the EU. Another restriction, another legitimate restriction of the right of access to court arises with time bars. And a time bar is, for example, it is a term after which I no longer have a right to litigate a particular issue. And then, for example, if I remember that my friend breached a contract with me 15 years ago, and I finally decide to bring this case to court, the law may say, this is way too late. We do not want to litigate something that is this old. It will clog the system to open up courts to cases that are so old, and because so much time has passed, the probability of us giving a correct judgment of finding the true facts is simply very low. So we would rather just let the past stay in the past. Once access to court has been granted, let's say in this scenario I do manage to go to court, and then we already factor in that the judge must be independent and impartial. Then there's a further guarantee that we find in Article 6 of the European Convention of Human Rights, and that's also present in all liberal countries. It is the right to a fair trial. Now that I've gotten to trial, the proceedings inside that trial must be fair. Factoring out the requirements of judicial independence and impartiality, because we have already discussed them, we can find in fair trial a big range of guarantees. For example, equality of arms, publicity, judgment within a reasonable time, or the fact that you must receive a reasoned judgment. The scope of these guarantees is very broad, and you can find information about them simply by reading the book. So, for example, equality of arms means that my capacity to defend myself in trial must be the same in terms of procedural opportunities as the capacity of the other party. So it cannot be, for example, that the other party can be a witness and I cannot be a witness. That the other party can call for experts to come testify in court and that I cannot do it. No, essentially, we must have the same ability to trigger procedural demands and to present evidence. The idea of publicity means that, at least in principle, the trial must occur in the light of day, with the possibility of a greater society seeing what's happening in the trial, and in particular that there should be a moment of the trial, some sort of hearing, where things are public, when things are viva voce, and not just in writing. The idea of a judgment within reasonable time is encapsulated in the phrase, justice delayed is justice denied. So if I have a fight with my neighbor because of the construction of a fence in the wrong place, and it takes 5 years for the courts to come to a decision about what is the right location of the fence, 5 years is too much of a weight for the service of justice to be provided in a way, something that takes that much time would not be fair at the level of duration. And the right to a reasoned judgment means that when a court makes a decision, it must explain in some way what are the grounds for reaching that opinion. This is, of course, important at the level of a basic respect granted to persons. If you treat somebody as a person and not merely as a thing, it means you are able to give reasons to that person about why that person has one treatment or another. At a basic level, there's that. But also, when you get a reasoned judgment, you are in a better position to appeal to that judgment to another court, because you're going able to say that the reasons given by the judge are invalid or biased for this or that ground. And this right to appeal, we will mention it very soon. This right to a fair trial is also not unlimited. There are some limitations that are specific to the circumstances at hand. For example, some sort of trials may be not public, they may be secret. For example, trials that discuss sensitive issues of state security, or trials where children participate and you want to protect the privacy of children by making the trial secret. Or secret within certain limits, not of course a fully secret trial. The principle of equality of harms can sometimes be limited by the need for ex parte decisions. An ex parte decision is a decision where only one party petitions something to the judge and the judge grants it without at the moment having the need to hear the other party. This may be needed, for example, in scenarios where if the other party finds out that this judgment is coming, he can take an illegitimate measure, for example, put his money out of the country. Then the judge might give the order ex parte and allow the other side to fight the decision only after the decision has been done. The right to fair trial is also not unlimited in a very essential sense by the fact that fair trial refers to a procedural equality within the parties, not a material equality within the parties. So where if it is the case that a very rich person is litigating against a very poor person, the quality of the lawyers hired by the former will not be the same as the quality of the lawyers hired by the latter. But the law will be satisfied by, let's say, the fairness of the proceedings if both parties have the ability to hire lawyers, and it will not inquire further into the economic imbalances that may be present in the trial. A fourth set of rights will have to do with how the evidence is assessed. That is to say, when the trial tries to assess what facts are true so that the law can be applied, how does the court go about in finding out which facts are true? Now, we have already said that both parties under equality of arms must have the same power to produce evidence and present it to the judge. Then the law will also typically have some sort of system for evaluating evidence. In the past, let's say 60, 70 years ago, it used to be the case that evidence would be weighted by the law. And then the law would say, for example, something along the lines of testimony will be worth 1 point, documentary evidence will be worth 2 points, etc. So to give a sense of which types of evidence are stronger than others. And then a witness might be of less value than a document because witnesses were more liable to lie or to change with time than a document. Most of the world by now has moved to a system of free assessment of evidence, where weights are not given beforehand. Judges are given the chance to assess the worth of the evidence contextually, in light of what they see, and then some witnesses may be considered more credible than some documents and vice versa. In addition to this, there will typically be some hard rules that prohibit certain forms of assessment of evidence that the law will simply consider, even without any contextual assessment, the law will consider improper. And examples of hard rules will be the principle that a witness is never enough to win a case, So presenting witnesses should not be sufficient. This must also be in addition to documentary evidence or on-site inspections or expert testimony and so forth. And in the criminal law, we also have the prohibition of self-incrimination. That's the idea that you can never be forced to declare yourself guilty, and that evidence where you declare yourself guilty should be out loud. And then fifth, the big fifth right that relates to procedures in the law is the right to appeal. And that is essentially the fact that if you have a judgment with which you are not satisfied, for example, because you lose the case or because you do not win everything that you think you have a right to win, you should, in principle, always be able to take this to another judge, to a higher judge, to get a second opinion. The right to appeal, you may think about it as the right of a legal second opinion. So if the judge says that you have to pay compensation and you think you don't, you can bring this to the district court or to the high court or to whatever is the name of the court that is hierarchically superior to the court in which the trial took place. The right to appeal is not infinite. Typically, you can only appeal once or twice in a specific case, but no more. Appeals will also typically be limited. The higher courts will not want to assess everything again, because that would create too much work for courts, and also because the higher courts would assume that the lower courts, which are closer to the ground, closer to where the things happen, are better placed to assess evidence. So typically a higher court will focus on issues of law and not on issues of fact. Also, there are very specialized appeals that are actually they're not called appeals, which are, for example, the French system of cassation. And that essentially means a very special calling to the highest court of the land to review a case. And cassation is not really a right, or it's, let's say, half a right. You have a right to petition for it, but it will only be granted if you fulfill very formal requirements. But the idea of appeal, we can leave it at that level of generality as this right of a second opinion. That if you get a judgment that is disfavorable or that you are in some way unsatisfied or believe that it's unjust, you're able to bring your case to a higher court and get a second opinion on the matter.